What is demurrage? With Quadraant Legal. Introduction. In shipping, time truly is money. Every extra hour a vessel waits at port costs the owner substantial sums. So what happens when a charterer takes longer than agreed to load or discharge cargo? The answer is demurrage. In today's video, we'll understand what demurrage means, how it is calculated, and the important clauses governing demurrage under charter parties. What is demurrage? Demurrage is a pre-agreed compensation payable by the charterer to the shipowner when the allowed laytime is exceeded. Laytime is the agreed period within which loading or discharge must be completed. If operations take longer than the agreed laytime, demurrage becomes payable at a fixed daily rate. It is not a penalty, it is liquidated damages agreed in advance. Legal basis. Demurrage is entirely contractual. It arises from the terms of the charter party agreement. Once a valid notice of readiness is tendered and laytime starts running, the clock continues until cargo operations are completed. If laytime expires, demurrage accrues automatically at the agreed rate. Calculation of demurrage. Demurrage calculation involves 4 elements. First, the total laytime allowed under the charter. Second, the actual laytime used. Third, the agreed daily demurrage rate. And fourth, calculation on a pro rata basis, meaning even part of a day is counted proportionately. For example, if demurrage is agreed at $20,000 per day, even a 12-hour delay may result in a $10,000 liability. Important demurrage clauses. On demurrage. Always on demurrage. One of the most important principles in shipping law is, once on demurrage, always on demurrage. This means that once laytime expires and demurrage begins, the clock continues to run continuously. Exceptions such as bad weather or holidays generally do not stop demurrage, unless specifically stated in the charter party. Exceptions clause. Some charter parties include exceptions clauses. These may exclude liability for delays caused by strikes, port closures, force majeure events, or government restrictions. However, unless the clause clearly applies to demurrage, courts often interpret it strictly. Ambiguity usually operates against the party seeking exemption. Demurrage time bar clause. Most modern charter parties include a demurrage time bar clause. This requires the shipowner to submit the demurrage claim within a specified period, often 30 or 90 days. Supporting documents such as statement of facts, notice of readiness, and timesheets must accompany the claim. Failure to comply may result in the claim being permanently barred. This makes documentation extremely important. Liquidated damages nature. Demurrage is considered liquidated damages. This means the parties have agreed in advance to a fixed compensation amount. The shipowner does not need to prove actual loss once laytime is exceeded. The agreed rate applies automatically. This provides certainty and avoids prolonged disputes over quantum of loss. Demurrage vs. dispatch. While demurrage compensates delay, dispatch rewards efficiency. If the charterer completes loading or discharge before laytime expires, they may be entitled to dispatch money, usually at half the demurrage rate. Both concepts ensure balanced risk allocation between owner and charterer. Conclusion. To summarize, demurrage is contractual compensation payable when laytime is exceeded. Its application depends entirely on charter party clauses, including time bar provisions and exceptions. In maritime law, precise drafting and strict compliance determine financial liability. If you found this video useful, like, share, and subscribe for more maritime law content. Drop your questions in the comments and we'll see you in the next video. The information provided here is for educational purpose only and does not constitute as a legal advice or solicitation. Welcome aboard. Like, share and subscribe.